IER, how can I help you? Oh, sí, señora, hablo español. Mi nombre es Sara. ¿En qué le puedo servir? Entonces, Nicolás.
IER at its heart is trying to fight employment discrimination based on citizenship status and national origin. And the way that we do that is we investigate and sue employers to see if they're discriminating against their workers. And then we also educate employers on their obligations and try to prevent discrimination. And we educate workers about their rights.
The Immigrant and Employee Rights section enforces the anti-discrimination provision of the Immigration and Nationality Act. This law prohibits 4 types of actions. The first is citizenship status discrimination. The second is national origin discrimination. The third is what we refer to as unfair documentary practices. And the last type of prohibited action is retaliation for the assertion of any rights that are protected under the anti-discrimination provision of the Immigration and Nationality Act.
Citizenship status discrimination is when an employer treats a person differently in hiring, firing, recruitment, or referral for a fee based on their citizenship status. An example of this type of discrimination would be if a company removed the job applicant from the hiring process because the individual is an asylee.
National origin discrimination is when an employer treats a worker differently in the hiring, firing, recruitment, or referral for a fee process based on the person's national origin. So for example, an employer who won't consider applicants who have foreign-sounding names, or when an employer doesn't want to hire someone because the person's ancestry is from a particular country.
Employers are not allowed to, when verifying a worker's employment eligibility, request more different or specific documents or reject reasonably genuine-looking documents because of the individual's citizenship status or national origin. An example of this is when an employer rejects a state ID and social security card from a lawful permanent resident and instead requests that they produce a permanent resident card because of the individual's citizenship status.
It's unlawful under the anti-discrimination provision of the INA to retaliate against someone for asserting a right under the anti-discrimination provision. It would be unlawful, for example, to retaliate against someone for having filed a charge with IER, for having contacted IER through its hotline, or for having assisted in an IER investigation. It is also unlawful to intimidate, threaten, or coerce an individual for the purpose of preventing them from asserting a right under the anti-discrimination provision.
IER operates hotlines for both employers and workers to provide information and assistance. In response to calls on our hotline, IER can sometimes informally intervene to resolve issues on the spot. So for example, I received a call from a lawful permanent resident whose employer had asked her to provide a new permanent resident card when her old one expired. Under the law, employers should not re-verify permanent resident cards when they expire. So I was able to reach out to the employer, provide some information, and the employer ultimately permitted the worker to continue working without providing any additional documents.
I took a call from a worker on IER's hotline, and this worker had an employment authorization document that was eligible for the automatic extension of her card for up to 180 days. The individual had presented her employer with the necessary paperwork to establish the automatic extension applied, but being unfamiliar with the rules, the employer terminated her employment. The individual called IER's hotline, and I happened to be on shift that day. I was able to get in touch with the employer, explain the automatic extension rules, point them in the direction of DHS's website, and after reviewing this information, the employer volunteered to reinstate that individual, and she was able to get back to work.
I can remember a situation where there was an asylee who quit his job to go work for a company because that company in large part had better benefits. And he was hired, and the first day of work he shows his driver's license and his unrestricted social security card, but the company wanted an immigration document from him, and so they actually fired him because he didn't have one. He called IER, and I called the employer and I explained the situation, and the employer was very excited because they had hired this worker, so they were glad that they were able to keep him. And I later found out for the worker that
that this was a tremendous benefit because his wife had cancer, and so he was going to have to interrupt her medical treatment because his health insurance had lapsed in between one job and the other, and so this really changed the trajectory of that family's life.
Members of the public can contact IER's hotline for free anonymous guidance. Employers can call to learn about their responsibilities and workers about their rights under the law that IER enforces. Our staff also conduct free live webinars that you can sign up for on our website. Our website also features educational flyers for both employers and worker advocates. IER is committed to language access, and several of our flyers are available in multiple languages. We also provide free spoken interpretation and written translation for the public as needed.